Welcome back. Just a standard disclaimer at the beginning of this video. This is for informational purposes only. It isn't meant as legal advice, and me telling you this information doesn't make me your lawyer. So now that we get that out of the way, I wanted to talk to you about an interesting litigation matter that's going on in the Federal Court of Claims, and actually has been going on since May of 2019. SpaceX, which we all know about with Elon Musk and such, filed a suit on May 17th in the Federal Court of Claims over a program called the Launch and Services Agreement that the Air Force put out to several companies. Basically, now, what you need to understand, this is basically a phase one. There are two phases, phase one and phase two. And it's phase one that SpaceX is suing for in the Federal Court of Claims. And when I say the Federal Court of Claims, I mean the dedicated federal court that basically companies that feel they've been aggrieved in our procurement process, and that's an important concept or a term to remember, can go and file suit and challenge the award in federal court. There are other methods through the GAO and such, but this time SpaceX chose to file in the Federal Court of Claims. Fundamentally, the SpaceX problems is the Air Force in phase one basically sent out and said, we will give you to companies, we will give you money to help develop a launcher if you can prove to us that you deserve it. Oversimplifying it, trust me, because the proposals that had to be sent in were doubtless very monumental and had to meet certain criteria. Long story short, United Launch Alliances and Blue Origin both got money from the Air Force under phase one of launch service agreements to develop a launcher. And that's fundamentally what phase one is all about, is the money that was awarded was to develop a new launch vehicle. SpaceX didn't win, and they got pretty upset about that. So they filed suit in the Federal Court of Claims. Now, I'm not going to bore you with the complaint because it's over 70 pages long, but fundamentally it comes down to this. The Air Force award was arbitrary and capricious, which is kind of a legal term of saying the only reason you didn't give us this award was because you don't like us or you have a personal grudge against us. It wasn't totally with the law. You didn't follow the rules when you denied us this award. That is making their whole argument and their complaint, lumping it into a few short sentences. It's a lot more complex than that. The legalese is pretty thick, but that's the way it is. Now, it's important to understand this complaint was originally filed under seal, meaning that basically SpaceX asserted that there are certain proprietary information that we're talking about in this complaint that we don't want out in the public. So what they're required to do is file later on a redacted complaint, redacting out the information they consider important. Fine. The Air Force came out and they read it, and basically they said, okay, we see this, and instead of answering it, they did what we call a motion to dismiss. Now, the federal rule that deals with motion to dismiss is Federal Rule 12B, and particularly what the Air Force filed was 12B1, which basically they are saying that the court lacks subject matter jurisdiction to hear this case. And that kind of perplexed me a little bit because I couldn't see the motion to dismiss because it was basically filed under a protective order, sealed because of proprietary information as well. But a little later on, they came out with a redacted version. And fundamentally, what they came down and said is that this court didn't have subject matter jurisdiction because this agreement wasn't a procurement contract under phase one. It was what they called an other transaction agreement. And that, I think I'm looking at reading the USC, it was something created by Congress under 12 USC sections 2371 and 2371B. So basically what the Air Force is saying is this was not a procurement contract under phase one. This money that was awarded to Blue Origin and United Launch Alliances was money that Congress allows us to award outside of standard procurement contracts. In other words, we're not buying a launcher, we are giving you money to develop a launcher. And because they're saying that this was another transaction agreement, that fundamentally this court, the Federal Court of Claims, does not have jurisdiction, which they're right, they don't, because the Federal Court of Claims basically deals with procurement contracts, disputes over procurement contracts. So that is the Air Force's argument lumped up in a nutshell, and basically I think they have a pretty good argument. How it will be ruled on, who knows? Now, this is the way I see it going. And I'm going to go back to, I think it was in 2014 or 2015 when SpaceX sued the Air Force again over the quote block buy that ULA got, the sweetheart deal that ULA got over those buying all those cores ahead of time, saying, well, the Air Force saying, well, we'll buy this many cores, and that way ULA could plan in advance on how much materials they would need to actually assemble these cores. SpaceX got ugly about it. They went in and sued in the federal court of claims, saying this was improper, yada yada yada. They were expressly left out of it. Now at this time they weren't certified by the Air Force for launchers, but another thing they didn't. Again, the crux of the Air Force's response in their motion to dismiss was also a B1 and a B2, or I can't remember which B it is. There are a lot of Bs in that certain rule. But basically, the Air Force says, look, they didn't follow the rules. There are these things called blue and gold rules for procurement contracts, and SpaceX, one, they didn't qualify for it because they weren't certified by the Air Force, and two, they didn't follow the blue and gold rules. Now, as an outsider looking in and not knowing the politics and the machinations and behind-the-scenes negotiations, I didn't know. I basically looked at it and said, you know what, this is a very solid argument, and I think the Air Force can win this. And I was really waiting for the court to rule on it, but the court was pushing settle, settle, settle. And guess what? The Air Force settled. And it kind of a disappointment to me because I really thought they had a strong argument. But basically the Air Force settled and said, okay, we'll give you a few more, we'll give you a few of these launches, these national security launches. Oh, and by the way, we'll expedite your certification to launch military and national security payloads. So in my opinion, though, that kind of gave SpaceX a little bit of, saying, hey, okay, we know how we can push them a little bit. Why they did it was, I suspect there was a little political maneuvering behind the scenes, because there were certain factions within Congress that didn't like ULA and were pushing for SpaceX. So I suspect some very influential people helped push that settlement along. Like I said, I think they could have won that. This case, I think the Air Force, again, has a very solid motion to dismiss. I think they could win on the motion. The question is, will it actually get to the point where they'll rule on the motion? And I'm kind of thinking it won't, for a couple of reasons. One, there is a prominent representative in Congress on the House Armed Services Committee who really likes SpaceX, and that is Representative Adam Smith from Washington. And he's actually the current chairman of the House Armed Services Committee. He basically, the way he has set up in the current NDAA being proposed, the National Defense Authorization Act being proposed, is basically that he will allocate $500 million subsidy for the company that wins under phase 2 of the launch services agreement, which is actually a procurement agreement to actually procure launches, and who did not receive a subsidy in phase 1. So, one, there's a $500 million subsidy for the winner for the winner of a launch to procure a launch procurement contract. In other words, to actually buy a launch, purchase future launches. And 3, who hasn't received subsidy from phase 1. Guess who that is? The only 2 people who really right now have rockets flying is ULA and SpaceX. And of those 2, the only 2 that hasn't received a subsidy under phase 1 is SpaceX. So this is kind of a gift to SpaceX, and I think it's something that might motivate either a settlement or actually get SpaceX to withdraw its suit. We'll have to see how it plays out. Being the holiday weekend, I didn't expect much to happen, but it'll be interesting to watch how it goes. So again, very interesting case. Of course, anything involving SpaceX is always of interest and always has some drama to it. But that's kind of the long and short of what's going on. Again, it is a 72-page complaint. The Air Force motion to dismiss is a little shorter. I have an account with Pacer, which is the government docketing system, so I can go online and I can look these up. Yes, it does cost me money to do it, but it's worth it to get the information I need, not only for my briefing letter, but also to do videos like this. So, what I want you to understand is, what basically the Air Force is saying is this wasn't a procurement contract. It was another transaction contract. The Federal Court of Claims doesn't have jurisdiction, which means I think they have a solid motion to dismiss, but I don't think it'll actually get to the point where it's ruled on, because they either settle or SpaceX will withdraw its complaint. They'll dismiss it on their own. So anyways, I will be back with videos updating this when I find out more information. And again, this is my second video for this new channel of mine. I encourage you to subscribe and tell your friends about it. And hopefully, as things get a little bit more, I get a little bit better with this, I'll throw in some fancy graphics and stuff, and hopefully better video quality. I'm doing this off my cell phone right now. So again, it's a gorgeous day out there. I'm gonna get off, upload this, and get out and enjoy it. And I want you to enjoy the rest of your weekend as well.